Swiping rights. When data breaches put you out of the closet. Master's thesis submitted in partial fulfillment of the requirements for the degree of Master of Laws in International Technology Law. Yuri Gomes Silva. 1. Introduction. 1.1. Problem definition. The research area of this master's thesis is linked to the access and use of personal and sensitive data belonging to members of the LGBT+ community by third parties, particularly through dating apps, with a focus on gay, bisexual men and transgender people, bearing in mind the complexity involved in discussing the LGBT+ community as a whole. According to Article 4, Paragraph 12 of the General Data Protection Regulation, GDPR, a personal data breach means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to, personal data transmitted, stored or otherwise processed. In other words, the GDPR establishes that data breaches can result from both accidental and deliberate causes. Thus, from this definition, this study will examine why and how data breaches in the digital era pose new threats to the LGBT+ community. It will also explore how dating apps can be used as surveillance tools and imperil LGBT+ rights, posing the question, do dating apps have positive obligations to keep data safe and be transparent about how they use it? As a starting point, the first chapter will discuss the existing legal framework in the European Union regarding the prohibition of discrimination on grounds of sexual orientation and gender identity and the importance of the rights to non-discrimination and equality as human rights. Additionally, it will clarify the reasons why sexual orientation is classified as sensitive data under the GDPR and its importance. As part of the introductory chapter, some practical examples will be given to demonstrate how companies can profit from having access to the personal and sensitive data of members of the LGBT+ community and how this can potentially harm this specific group. Hence, it will attempt to tackle the main concerns of collecting data from the LGBT+ community, showing its pros and cons. In a later stage, in the second chapter of this master's thesis, it will be debated some real cases of data breaches caused by dating apps of worldwide magnitude, and in a similar fashion, it will be discussed how dating apps, such as Grindr, have been used so far as surveillance and persecution tools of gays, bisexual men and transgenders, even without the existence of data breaches. Further, it will be assessed whether the GDPR imposes security and transparency obligations to data processors in order to evaluate what behavior and measures LGBT+ users can legitimately expect from dating apps regarding their data. Last but not least, in the third and final chapter, the privacy policies of some dating apps, namely Grindr, Tinder, and Hornet, will be examined in an attempt to assess what they do to provide their users with enough security and transparency regarding data processing and whether they are in compliance with the GDPR. Moreover, a deeper look at the GDPR and the privacy policy.
Sample complete. Ready to continue?